friends, Namaskaram, how are you? In today's class, I will discuss one of the most important topic, which is concerned with the questioning jurisdiction of Honorable High Court. Sometimes it is seen that while moving for the questioning, you might be in the anxiety or in hurry. So basically, what steps we must follow and what precaution we must observe so that we could chalk out a good case for the questioning. So from the practical experience of myself, I'm going to specify you the common mistakes which we usually commit, but things are technical in nature, so I request all of you to maintain the proper record and try to apply the principles to your case. Directly we are moving on the board. The questioning is basically indication of inherent power of Honorable High Court. It is concerned with abuse of process. And abuse of process simply means the proceedings against law. And regarding questioning, Section 482 of CRPC or Section 5 to 8 of BNSS are quite important. But the keyword is the proceedings must be abuse of process. It must be against law. So, for questioning, we have to note down certain fundamentals. Simply, I could say these are golden rules. Rule number 1, read the entire FIR. Point out that your role is not specific, or allegations are general, or vague, or omnibus. As per certain legal position, if allegations are general, vague, or omnibus, it is a fit case for questioning. The citation is Kakasha versus State of Bihar. Judgment is pronounced by Honorable Supreme Court of India. Number 1. Number 2, give the memorandum, means defense line to the concerned IO without any worry or a second thought. The reason being is that the IO is bound to investigate on your facts. If you fail to do so and simply he filed a charge sheet, you may chalk out a case for unfair investigation. For example, Mr. A says, I have given rupees 2 lakh to Mr. B. And Mr. B in the memorandum submits that rupees 2 lakh had been refunded. But document was not considered and charge sheet is filed. In that scenario, the proceeding will be abuse of process. Because investigation never mean that it should be for the prosecution. If any defense document or anything submitted by the consent accused by the virtue of which he could recognize his innocence, the document is required to be considered, and if it is not considered in that scenario, the concerned authority might infringe Article 21 of the Constitution. Please be noted. So simply we could say that fair investigation is fundamental right of accused. Number 3, even after filing of charge sheet, you may go for questioning without any worry. There are multiple queries from client whether we can go after filing of charge sheet. Yes, you can go. Number 4, you have to emphasize on the legal compliances, if any. For example, in a corruption case, if a case is confined up to demand only, Section 17A of PCACT is imperative as per guidance of Honorable Rajasthan High Court. If the benefit is not given, in that scenario, the proceeding could be challenged. So basically, we have to observe the legal compliances as well. We are taking another example. If Mr. A is prosecuted as per Section 7 of PCACT, you got my point? And Mr. A is not the public servant, he is basically a private person. And there is no public servant on record. So as per law, the prosecution is illegal or abuse of process. So Mr. A could file the quashing petition on that point. Number 5, we have to observe the ingredients of the offense. If there is no ingredient, then we could have the benefit. For example, Mr. A is prosecuted for cheating. For cheating, the prosecution has to show that the accused is having the dishonest intention. He induced valuable things or money is interested, and finally he misappropriated the same, and despite of demand he failed to return. In that scenario, cheating will be made out. But if there is a mere civil dispute, in that scenario the ingredient of dishonest intention, inducement, entrustment would be absent. So prosecution will be abuse of process. On that point, we could emphasize. Please be noted. We have to keep in our mind that the documents means FIR, charge sheet, and documents on which we are going to rely must be annexed with the petition as per guidelines of Honorable Supreme Court. That is Pragya versus State of Maharashtra. Judgment date is 3rd of September 2025. We have to emphasize that the process is abuse of law, the proceedings are malafide, and investigation is not as per the norms. So these are the fundamentals of quashing jurisdiction. And apart from that, if there is any legal position to sustain the case, for example, Mr. A is prosecuted for cheating, but his case is that there is a civil dispute between the parties, and as per legal position, if there is a civil dispute between the parties, the case of cheating will not made out, and the legal position sustained by Honorable Supreme Court is available. He must avert the same in the petition as well. And regarding that dispute, he could rely on judgment of Honorable Supreme Court, that is 2000 volume 2 SCC page 636, and apart from that, judgment of Honorable Supreme Court, that is 2023 SCC online page 90 is important. In both judgment, it is specified that civil dispute could not be the basis for prosecution of cheating. So now it is clear to us that fundamentals are quite important while moving for the quashing. Recently, what we are doing, simply we engage a lawyer, we move for the petition for quashing. Do not be in the anxiety. Do not be in the panic. Just read the FIR, make proper memorandum, do proper review along with making of defense line, then go further. If there is no proper review and our decision is in anxiety, in that scenario we could not be succeeded. We have to work on the fundamentals. So simply we could say that while moving for the quashing, the abuse of process, the malafidness on part of complainant, which includes concealment of fact also, and malafide investigation and unlawful investigation is also important while chalking out a case for quashing. So on these fundamentals we have to proceed. So in the simple manner, I have specified you the fundamentals. So whenever we are going to move for the question, do not be in the anxiety. Just observe the FIR, find out your role. If it is not specific, you could have the benefit. And apart from that, there is no legal compliances. Again, we could have the benefit. And in addition to this, if there is no ingredients and the memo submitted by us is not considered by the IO, in that scenario, we could have the benefit. So we have to observe the things. If things are in our favor, and apart from that, there are concealment, there is inconsistency, there is lack of corroboration, and entire prosecution is against law, then definitely we could have the benefit in questioning jurisdiction. See you in the next video.